Time is money.
Welcome to YD. Why do Germans do things the way they do?
Like everything else in Germany, working hours are strictly regulated. Today, we will take a look at how working hours are regulated. As always, I'm not a solicitor or lawyer, so I cannot give legal advice. I'm summarizing law statements from solicitors and my experience working with human resources departments. For further information, please check the sources or ask a solicitor, perhaps through your trade union. I already had a video here about holidays, so today we will also limit ourselves to working hours, breaks, and rest periods. Working days in Germany are Monday to Saturday, excluding public holidays. Employers who want to have their staff work on Sundays or public holidays must have a business license in accordance with paragraph 10 or a special exemption. Of course, hospitals and railways, as well as restaurants or taxi companies, are allowed to work on Sundays and public holidays, but even a blast furnace cannot simply be shut down for a day. However, if, for example, inventory in retail is to be carried out on a Sunday when there are no customers in the shop, or if a computer system changeover is to take place over a long weekend, the company must submit an application to the relevant authority in advance and wait for permission. Even as an employee, it would be prohibited to simply prepare something for the following week on Sunday if no corresponding request had been approved in advance. Sundays and public holidays are still sacred in secular Germany. If we assume a normal daily working time, this is 8 hours per day for full-time employees, but can be extended to 10 hours per day if the average over half a year is 8 hours. For example, if you work 10 hours per working day during the planting season in a nursery in the October or in spring, you could perhaps work only 6 hours in winter to average 8 hours. For a certain period of time, it would be possible to work 6 times 10 hours, what is 60 hours per week. Working more than 10 hours per day is generally not permitted. However, there are two main exceptions to this rule. The first exception is emergencies. For example, if the servers fail and the IT staff work longer than 10 hours to resolve the issue. In this case, the overtime must be recorded and justified accordingly. Another exception typically involves services that include on-call duty, Bereitschaft, such as 24-hour shifts in hospitals or fire departments and sometimes in security services. Security service sometimes have 12-hour shifts, but these require special regulations and often union agreements. But you also need breaks. After 6 hours of work at the latest, there must be at least a half-hour break. After 9 hours, there must be a total of at least 45 minutes of break. There are stricter rules for minors regarding working hours and breaks, which I have already discussed here. Incidentally, breaks must be determined in advance. So if you start work in the morning, you need to know when you will taking your break. Those who work in production will probably have fixed shift and break times. However, those who work in an office or in retail should also know in advance when their break will be. These breaks can also be split up, but they cannot be shorter than 15 minutes. So if you take 6 5-minute cigarette breaks, you have taken 30 minutes break, but not a single worthwhile break, and therefore you need to take another 30 minutes break. And if you're supposed to take a break and you have sat down for 5 minutes, but are then disturbed because a patient or a customer comes in and your boss says you have to help them, then you have not had a break yet. It is important that the company is responsible for ensuring that you take sufficient breaks. Even workaholics have to take breaks or they may be reprimanded by the company. Restrictions on working hours, adequate breaks, and rest periods serve to protect the health of the employee. Speaking of rest periods, there must be at least 11 hours between two working days. So, driving home from the late shift at 10 p.m. and then going back to work at 6 a.m. for the early shift is not possible. I don't know of any company in Germany that would schedule its employees like that. What can happen, however, is that winter service employees, IT service technicians, electricians, or plumbers may be on call for emergencies. If the employee finishes work at 6 p.m. and drives home, taking their mobile phone with them in case a customer or the company calls for on call assistance, and the call actually comes in at 10 p.m. and the employee then provides assistance until midnight, then the start of the rest period is after midnight. This employee is therefore not allowed to start work before 11 a.m. the next day. In the public sector, working hours are then credited from the normal start of work until the time when work is actually permitted to begin. The municipal winter service employee is then credited with the time from, for example, 9 a.m. to 11 a.m. as worked because it was not his fault that he was unable to start work. In contrast to the on-call duty, Rufbereitschaft, there is an on-site duty for Ortbereitschaft. This on-site duty is often performed by doctors in hospitals. It also sometimes exists in security services or, for example, in the armed forces Bundeswehr, which, however, have their own rules on working hours. On-site duty is characterized by the fact that you usually have to be at a fixed location, for example, the on-call room in the hospital, or the security services operations center, or at the fire station. Furthermore, the actual work performed should generally amount to less than half of the on-call time. There are also collective agreements on this, such as those from the Marburger Bund for doctors or the collective agreement for public sector, TVÖD. On-call time must also be remunerated, though not necessarily in the same way as other working time. According to a ruling by the Federal Labor Court, Bundesarbeitsgericht, on 13 September 2022, employers must record working hours. On 14th May 2019, the European Court of Justice ruled that employers must record their employees' working hours. In 2023, the working hours of 82% of employees surveyed in Germany were recorded. Some industries and anyone earning the minimum wage already had to record their working hours. It is important to note that working hours must be recorded as they are incurred. Employers who require employees to clock in later or clock out earlier, even though they are still working, are in violation of the law. According to the ruling, a works council in a company has the right to require the employer to introduce a time recording system. Incidentally, there is no difference in what employees do or where they work. Even law firms are not entitled to be exempt from time recording. Anything you do for the company on the company's instructions is also considered working time. It is important not to confuse project time, which may be spent on a specific project or cost center, with working time. If an employee is supposed to drive to a meeting with a customer at 9 a.m. and the customer is an hour late, that hour spent waiting is still working time. You may not be able to bill the customer for it or charge it to a project, but it's still time worked. If you take advantage of the opportunity and bring your breakfast break forward, you may have already taken half an hour of your hour-long waiting as a break, but you cannot expect the employee to take the entire hour as break, as this was not planned at the beginning of the working day. The business trip to the customer is also likely to be working time. If you drive a car during working hours, you are also working. However, if you travel by train or as a passenger, this time may be remunerated differently than the normal hourly wage. How exactly this is recorded is not yet precisely defined in the law. Many companies have time clocks with a connected system that calculates working time from the clocking in and out times and breaks. Depending on the industry, this may include possible bonuses for night work or on-call duty. As I already showed in this video on employment contracts, working hours and the location of working hours are also part of the employment contract and can only be changed by mutual agreement. If shift work is stipulated in the employment contract, binding shift planning is also possible. If you are pregnant or a minor, special protection rights apply, for example, with regard to possible night work. If you notice any change to the times you have stamped or entered, you should talk to the Works Council or trade union. If there is no Works Council and you're not a member of a trade union, ask the Human Resources Department. It may be that the contract or works agreement contains provisions on rounding or reduction. Otherwise, have your employment contract and time recording documents checked by a solicitor. As already mentioned several times, if there has been an overpayment, the money is usually offset against the next payslip. A direct repayment while you are still employed in cash at the end is almost always a sign of fraud.
Remarks, additions, and comments in the comments. Thank you for your attention. See you in the next video.